The senator from Louisiana.
Mr. Chief Justice, along with Senator Blackburn and Senator Cornyn, I send a question to the desk for the House managers and for counsel for the President.
In the case of such a question addressed to both sides, they will split the 5 minutes equally. The senators ask, why did the House of Representatives not challenge President Trump's claims of executive privilege and/or immunity during the House impeachment proceedings? We'll begin with the House managers. We'll have to start the clock soon.
Mr. Chief Justice, distinguished senators, thank you for your question. The answer is simple. We did not challenge any claims related to executive privilege because, as the President's own counsel admitted during this trial, the President never raised the question of executive privilege. What the President did raise was this notion of blanket defiance, this notion that the executive branch, directed by the President, could completely defy any and all subpoenas issued by the House of Representatives, not turn over documents, not turn over witnesses, not produce a single shred of information in order to allow us to present the truth to the American people. In the October 8th letter that was sent to the House of Representatives, there was no jurisprudence that was cited to justify the notion of blanket defiance. There has been no case law cited to justify the doctrine of absolute immunity. In fact, every single court that has considered any presidential claim of absolute immunity, such as the one asserted by the White House, has rejected it out of hand.
Counsel for the President.
Mr. Chief Justice, Senators, thank you for that question. Let me frame this partly in response to what Manager Jeffries said, and I went through this before. The idea that there was blanket defiance and no explanation and no case law from the White House is simply incorrect. I put up slides showing the letters, a letter from October 18th that explained specifically that the subpoenas that had been issued by the House because they were not authorized by a vote from the House were invalid. And there was a letter from the White House counsel saying that. There was a letter from OMB saying that. There was a letter from the State Department saying that. There were specific rationales given, citing the cases, Watkins, Roomley, and others, explaining that defect. The House managers, Manager Schiff, chose not to take any steps to correct that. We also pointed out other defects. We asserted the doctrine of absolute immunity for senior advisors to the President, which has been asserted by every president since the 1970s. They chose not to challenge that in court. We also explained the problem that they didn't allow agency counsel to be present at depositions. They chose not to challenge that in court. These were specific legal reasons, not blanket defiance, right? That's just a misrepresentation of the record. And there was no attempt to have that adjudicated in court. And the reason that there was no attempt is that the House Democrats were just in a hurry. They had a timetable. One of the House managers said on the floor here, they had no time for courts. They had to impeach the president before the election. So they had to have that done by Christmas. That's why the proper process wasn't followed here, because it was a partisan and political impeachment that they wanted to get done all around timing for the election. Thank you.
Thank you, counsel.